Welcome to this high-stakes overview of NASAA, the North American Securities Administrators Association. Founded in Kansas in 1919, NASAA is the oldest international organization dedicated to investor protection. It represents 67 state, provincial, and territorial regulators across North America, including all 50 U.S. states, the District of Columbia, and Puerto Rico. It is crucial to understand that NASAA is not a federal agency and holds no independent enforcement authority. Instead, it serves as a powerful coordinating body. NASAA sets regulatory standards and develops model legislation, such as the Uniform Securities Act, which defines the landscape of modern state securities law. This voluntary association ensures that regulators speak collectively on investor protection policy before Congress, the SEC, and other federal bodies. The structural mechanics of NASAA are most visible through its rigorous examination program, which qualifies industry professionals for state-level registration. The Series 63 focuses on the Uniform Securities Act, featuring 60 scored questions and requiring a 72% passing threshold for agents. The Series 65 is essential for investment advisor representatives. It is a 3-hour marathon with 130 scored questions on state law. Finally, the Series 66 combines these requirements for dually registered candidates, focusing on the state law portion of the investment advisor exam. This examination requires a 73% passing score and covers the essential regulatory framework for state-registered investment professionals. Critically, the Series 65 and 66 do not require firm sponsorship. This is a vital distinction for many candidates entering the industry. This allows individuals to meet these professional benchmarks independently, pursuing their licensing thresholds before joining a broker-dealer or investment advisor. Mastering these numeric triggers, thresholds, and look-back windows is absolutely fundamental to your success on exam day and your future career. Understand that these exams are developed by NASAA, but administered by FINRA under a long-standing service agreement between the two organizations. NASAA publishes authoritative content outlines for all 3 exams, which should be your primary guide for all examination preparation. State administrators exercise broad statutory authority over the operational boundaries of the securities industry within their specific jurisdictions. Under local blue sky laws, these officials possess the power to register, deny, or even revoke the licenses of broker-dealers and agents. Because they are geographically closest to the investors they protect, state regulators are uniquely effective at identifying locally concentrated fraud schemes. They play a critical role in protecting vulnerable seniors and ensuring that local financial professionals operate with the highest levels of integrity. Their oversight extends to physical requirements, such as conduct on banking premises and the specific mechanics of mandatory disclosure delivery. Administrators mandate dual-channel compliance to ensure that every investor receives clear, actionable information before making any significant financial decisions. Administrators have the power to issue subpoenas, cease and desist orders, and can impose significant civil monetary penalties for violations of state law. In serious cases, they can refer criminal matters to the state attorney general for prosecution, ensuring that bad actors are held fully accountable. This dual-channel mandate ensures that every professional operates within a strictly defined jurisdictional cage, maintaining the highest standards of conduct. By maintaining jurisdictional integrity, state administrators complement federal supervision while providing a specialized focus on their local communities. Ultimately, the operational requirements set by state administrators are the foundation of trust in the North American securities markets. Supervisory controls are anchored by the National Securities Markets Improvement Act of 1996, which clearly divides state and federal regulatory jurisdiction. State administrators retain primary registration authority over investment advisors managing less than $100 million in assets under management. They also maintain concurrent fraud enforcement authority over all market participants within their borders, regardless of their federal registration status. NASAA facilitates this through multi-state enforcement coordination, allowing administrators to pool intelligence and share evidence across various jurisdictions. This integration ensures that written supervisory procedures and books and records retention cycles remain compliant with both state and federal statutes. State administrators are the frontline defense in the dual regulatory system, ensuring that firm supervision is as local as the investors it serves. To wrap up, let's review the critical points you must retain. NASAA is a voluntary international coordinating body, not a federal enforcer. It develops the Series 63, 65, and 66 exams, and notably, the 65 and 66 can be taken without a sponsoring firm. Finally, State administrators hold primary jurisdiction over smaller investment advisors and localized fraud enforcement under the NSMIA framework. Mastery of these distinctions is your competitive advantage in the regulatory environment. It is the key to passing your exams and succeeding in the industry. Stay sharp, stay compliant, and use this knowledge to provide the highest level of service to your clients. Thank you for joining this regulatory deep dive.